Well, good morning, good afternoon, good evening to all of you who are joined with us live here on Co-working Live with Red Worldwide. I'm Patience Rose, and we are here again another day with one of our podcasting episodes. And so we're excited for those of you who have joined us. We were really excited about what we learned yesterday on Tech Thursday. And today we're going to do a little bit deeper dive into some estate planning aspects of the protection side of what we do. Many of you are aware that Red Worldwide is a nonprofit, and we are really heavy into education. We try to educate business owners and individuals who are aspiring business owners, people who are executives, families. We try to provide education in all of those realms. And so our acronym RED it stands for Research, Educate, and Develop. And we try to provide you with as many tools as necessary so that you can launch, grow, and protect your wealth. Okay, protect, launch your businesses, launch your service-based business, launch your products and services, within the guise of whatever it is that you're doing, grow them to the levels that they need to be, pivot when necessary, but persevere regardless. And then we want to help you to protect your wealth. And so in that, there is a lot on the protection side. And some of you have been a part of some of our previous uh, things that we've done. We've done a lot of webinars and some live events where we talk a lot about protection, about combining your estate planning with your commercial activities so that you could better protect your assets, insulating yourselves, insulating your families, protecting the family so that you would not put what you've worked so hard for at risk. And we talk about ways that we could do this and make sure that there are no stones left unturned. However, we've gotten a few questions along the way, and we want to really answer those questions, by providing you with more information. And so the way that we're going to do that is today we're going to jump in here and really delve into areas that have to do with the estate planning. So I'm going to be pulling up our slides in a few minutes because I want us to, have access to this wonderful set of information that, I believe will help to kind of close the gap for those of you who have not been in a position, where you have the information readily available, to you. Sometimes, the lack of information really does cause us to make different decisions than we probably should, because we're working in the blind. We don't know what we don't know. And so in this case, I'm going to answer a lot of questions today. I've had, some questions about, well, what is probate, and why is it important? Or for that matter, why should, I be looking at a living trust over a will? Why do I need a pour over will or a last will and testament and the living trust? Couldn't I just use one or the other? And so all of these things are questions that, have been popping up lately. And for that reason, we're just going to delve into it and get some good information and, try to see what we can do, to make sure that everyone is in a position of where they do understand. And so this is a part of a presentation that we do frequently called Maximizing Financial Capacity. But what we're going to do is we're going to kind of scroll through and get to the part of this presentation that really is going to help us understand, a little better, the probate process and how it works, and, what you need to know about it, to help you make some better decisions, in your own life. Okay, so I have some people in the studio audience. I want to make sure that everybody can see the full presentation. And if you can see the full presentation, I just want you to give me a thumbs up real quick. Okay, got it. Wonderful. So what is probate anyway? Okay. And I want to tell you that, we're really looking at this from the standpoint of reducing our exposure and risk. Okay. So as people who are living in America, okay, And it doesn't work the same way in other countries. I do need to make sure that I'm very clear about that, because in some places they don't have probate. They have other processes that are similar. Like in France, they have what's called succession. In Mexico, they have that same process, and it works a little differently than it does here. So we're only really focused on what happens in the United States today. So I want to be very clear about that, because, unfortunately, if you take this information and try to use it outside of the US, you'll find that some things don't work quite the same way. But probate is a formal procedure that the government uses to help sort out and distribute a deceased person's estate. It occurs when no instructions are provided or the instructions are unclear and do not meet the procedural test to avoid government intervention. So I tell people this all the time. It's literally the government's answer or their response to when you pass away and you leave, people with instructions that are not necessarily formal enough for them to utilize them, or they're incomplete. They can't use them to dispose of your assets and to pay off your debts properly. And so for people who don't leave any will at all, or any type of instructions at all in writing, that's one way that they have to intervene. But when people leave just a will, and the will itself of course doesn't have all of the information in it, it just says what you want to pass on to someone, and it just says, potentially who you want those things to pass to, but it doesn't give all of the answers. It doesn't answer all the questions for the government. And so for that reason, they intervene, and for most of us, we have, assets that, may be, things that are really, really important to us to get to other people. Some people don't have a lot of assets, but they're still assets. Some people may have a house, or, they might have cars, or they might have furnishings. But I want you to be very much aware, whatever it is that you have that you really were trying to get into the hands of your family members, if you don't leave good instructions, then the government will intervene, and they will use their process to take care of your assets. And sometimes it leaves unintended consequences. So let's talk about how probate works. Well, probate determines the legitimacy of your will if you leave a will. Okay. The court first checks if the deceased person's will is legally valid, meaning it was actually written the way that it's supposed to be written, and it has all of the proper information on there for them to identify who you were or are, in this particular case, and who the people are, that are supposed to get the assets. Okay. Then of course they identify the property. It involves taking an inventory, of the person who has passed away's property. They appraise the property. The assets may need to be, evaluated in some form to establish how much they're really worth. Okay. Because sometimes what we think certain things are worth, either the value could exceed our expectations, or it may be not as much as we thought, and then of course, if we have left debts or taxes, before any of those assets can be given out, our debts and taxes have to be paid off. And after that, whatever's left, then that's what the family members, the heirs, or the beneficiaries, actually will get. And this is something that people don't really understand, that what they think they're leaving may not be what they're leaving if they don't leave the right type of documentation, and if it has to go through probate, it's almost invariably true that what they've left or is not going to be what the person gets, because there's a cost associated with probate. So let's talk about that. The cost of probate can vary widely. I mean, it can be, anywhere from a smaller amount of money to a very large amount of money, that the probate process can cost, and that really has to do with the factors of, whether or not there are a certain amount of fees that have been associated with this process, because some states or jurisdictions have larger fees than others. And if the estate is complex, meaning that there are lots of different types of assets, not necessarily the amount is there, but there are many different kinds of assets, and some things may have a more of a difficulty finding out what they're worth, then that's more work. And of course, that costs more money. Okay. So, whether there are legal disputes also between the heirs, that could also make it work, cost more. So let's kind of look at this in a nutshell. Probate has these following considerations for fees. There's court fees, attorney's fees, executor fees, bond fees, appraisal and valuation fees, accounting fees, miscellaneous fees. There are lots of fees that could be associated with the probate process. And some people that I have been, they're clients of ours, I've seen them pay, a lot less than, $10,000. But I'm telling you, I've seen people pay in excess of $10,000 in a probate process. I've seen people lose a house in a probate process because they didn't have the money to pay the other fees. There wasn't enough money in the estate to do that. And so the house had to be sold or other things had to happen in order for the fees to be paid from the probate process. And the people who were designated to get the house never got it. Okay, so probate can be costly. It can be public. It can be lengthy because, again, this is a public process. And so when something is going through probate, it is published information. It is established and it's free for people to go and get that information. So if you're trying to make it so that your assets get transferred to your heirs without that public, costly, and lengthy process, then you've got to follow other processes to make sure that happen. And there's only one sure way to avoid probate. And that is careful estate planning. Okay, that includes the use of trusts, joint ownership, continuity planning, and beneficiary designations. When you are able to have a solid plan, okay, that the court system respects, then you do not have to have your assets go through probate. And you can actually transfer your estate, everything that's there to your children or whoever your other heirs might be or beneficiaries without going through any government intervention. All right, so let's talk about the trust that you could use, as an effective tool for avoiding probate. And this is the living trust. It's a revocable trust. And some of you guys have heard my rendition to talk how I talk about the federal government has two categories, the simple or the revocable, or the complex, or which is the irrevocable. So the revocable trust is still you. Okay. It operates off of your Social Security number, essentially. And is one of the most effective tools for avoiding probate because the assets are placed in trust by you as a creator, managed by a trustee, or you could be the trustee for the benefit of the beneficiaries, which could also be you and whoever you designate. The creator, you, names a successor for the continuity. So in other words, if something happens where you become too ill to manage the estate yourself, and I'm calling it an estate, it's an estate after you pass away, but your assets while you're living, if you are too ill or for whatever reason, you just don't want to do it, don't choose to do it, you could have a person that actually succeeds you as trustee, and they could be the party that's actually managing on your behalf. And upon your passing away, upon your death, the assets that are in trust are distributed directly to the beneficiaries according to the terms of the trust without going through probate. So this is an acceptable way, for the courts to not have to put your assets through probate. Now, I have to tell you this because most people don't, or I won't say most, but a lot of people don't realize that when you have a living trust, but you don't also have the last will and testament or the pour over will coupled with that living trust, then it's incomplete. And I'm going to tell you why. Because when you set the living trust up, there's a date that is associated with that trust. And unfortunately, you may, not realize this, but if you pass away after that date and you have amassed other assets, those assets are not automatically considered to be a part of your living trust. You have to designate them. And the way you do that is by having a pour over will or a last will and testament that basically says, whatever I have amassed since I established my living trust with the name of the living trust in there, okay, in that document, those items are to be a part of my living trust or my estate. All right. And so that connects whatever you have, accumulated since the time that you've had your living trust. Now, one other way that you could do it, if you are managing your living trust or if you're having it to be managed by someone else as the trustee, that you have an annual review of your living trust just to make sure that if there's something else that needs to be put in there that has come after you established it, you can actually make those changes and put those things in the living trust. And so this annual review, and some people, have it more than annually. Sometimes people have it quarterly if they have a lot of assets and they're moving a lot of moving parts. They're adding new accounts or they're adding new homes or they have other businesses that they need to have named or there's other changes with regards to their children. They are having these quarterly meetings and they're adding these things to the living trust to make sure that the living trust itself does not end up being, outdated without the proper information in there. So this is something that you could do if you do have a lot of moving parts and things are happening quickly for you and your spouse or designated your registered domestic partner or whoever else you have there in your trust. Okay. All right. So with that said, let's look at some key benefits of a living trust. Well, flexibility and control. It is revocable, and the person who creates the trust can modify it or dissolve it at any time during their lifetime. This flexibility does really allow a grantor or creator, that's the same thing, or settler, all three of those names mean the same thing, to adapt the trust to their own circumstances and their goals, and this is a living document. So because it's a living document, it means that it is living and breathing like you are. Okay. So you have changes that are being made and you have things that are happening. So your document should reflect that. And there's control in the document. The grantor can act as the trustee, maintaining control over their own assets and their distributions of those assets while they're alive. Probate avoidance, it is an efficient asset transfer. Upon the grantor's death, the assets in the trust are transferred to the beneficiaries according to the terms that are in that trust. And I have said this over and over again, and I'll say it again. When something has to go to court because of the fact that there's maybe someone trying to contest the trust or whatever, the judge doesn't say, let me see the probate code or let me go and look at, the commercial code, or for that matter, let me look at the Internal Revenue Code. What they say is, let me see the trust document, because that document is what specifies the instructions. And so they're looking for these instructions. And what speeds up the distribution process is the fact that these assets that are in the trust are named. So it's easy for someone to look and say, oh, here's a checking account. Here's a savings account. Here is a 401k. Here is, all of these things, the IRA, all these things are listed. There's a car, there's furniture, there's furs, there's, art. All of this stuff is listed inside of the trust document. So it's easy for someone to make the transfer. And usually inside of your trust, it's going to give kind of an amount of evaluation of what those items are worth at the time that the trust was done. And it will probably also add if there's specific distributions to a specific party. So let's say that you had a family Bible that you wanted to go to your cousin. Okay. And that cousin is named as a beneficiary. Then what can happen is the person who is a trustee at that time, when you pass away, they can make those things, that movement occur. So this is really, really important for people to understand that the way that this occurs is through the process of the written information inside of the trust document. Now, the other thing is that it's good for the management during an incapacity. When you're in a situation where you are ill or otherwise incapacitated, you can actually have someone else's um, I mean, position, where as a successor, jump up to the trustee at that point. And when they become the trustee, they can manage your assets, ensuring that your financial needs are met without the need of a court appointed guardian. And so that's another really important thing, because now you have continuity for making sure that you're taken care of in the case of, something happening to you that is outside of your control, but you can manage on, these items, at your from before anything happens to you by putting the instructions inside of the living trust. Okay. So this coordinated management is going to be really important, because I want you to understand that the living trust alone, and let me just go back to this living trust, although it does protect from probate, it does not protect from creditors. And the other thing that you need to understand about it is that it does not reduce tax. I've heard people say, well, I'm just going to put these things over into my living trust and it's going to help me reduce my taxes. And it's nowhere in the Internal Revenue Code that a living trust can help to reduce your tax. It just is not there. And so we have to understand that because it's still you and it's operating off of your Social Security number, your taxes are still your taxes when regards to all of the income that's coming in to you. The living trust is only there to protect you from having your assets go through probate and giving you some control, of the assets, during your lifetime. Okay. As well as making sure that you can designate what you want done in your death. Okay. So now we want to talk about how can you get some of this protection and reduction from, tax protection from, these predators and editors and creditors. Okay. How can you make that happen? Well, you can combine your living trust with an irrevocable family trust and create a comprehensive and solid estate plan. It gives you the ability to manage and protect your assets during your lifetime and beyond, while also addressing your tax implications and ensuring the long-term financial security for your heirs. So, what are the key benefits of the family trust? Well, let's look at this, because I want you to understand that there are a lot of benefits, to having an irrevocable family trust. The first thing is that it's the complex trust. It's the not you trust. It has its own EIN number. And because it has its own EIN number, it's separated from you. So when you have an irrevocable family trust, it's permanent, and generally it cannot be altered or revoked by the person who created it, the grantor. Okay. Whoever that is, whether it's your grandmother, your grandfather, your mother, your father, your attorney, whoever it is that created that trust for you, who granted that trust to you as trustee, you must understand, if you're in this position as grantor, you will never be able to revoke that trust, and you will most definitely not have access to anything that you transferred into the trust once you've transferred those items into the trust. Now, for people who are the trustees, yes, you can have access to what's in the trust to do what it is that the trust was created for you to do. Follow the instructions that are in the trust document under the powers of the trustee, and make sure that all of the things that were intended by the trust is done. So what are the tax benefits? Well, there's some estate tax reduction, and by transferring the assets into an irrevocable trust, those assets are no longer considered a part of the grantor's estate for tax purposes. So once they've been separated out of that estate, now they're in the trust and they are not available for tax. This not for anything that is going on by the grantor. Okay. Once they've been put into the trust, however they got into the trust, they're now separated from who put them in the trust. And at this point in time, this now is income that is no longer available for tax purposes to the person or party who placed them in there. This can significantly reduce the estate tax upon the grantor's death, especially when there's a large estate, right? Okay. And so we want to be, understanding that, let's just say that you have connected your living trust with a family trust, and the assets that are in the living trust move at your death to the family trust. Once they do that, there's an immediate reduction, okay, in the estate tax. Okay, so, and the other thing you have to understand about gift tax, the transfers to the trust, they may be subject to a gift tax at the time of transfer, but they can utilize the lifetime gift tax exemption if they're being put in there by the grantor. Okay, and there's a lifetime gift tax exemption, and it changes every year, generally. And so, based on whatever year this is, and whatever year you actually are passing away, you have some flexibility there. The year that it is when the gift tax is imposed. So whatever year that the items are being placed in trust, that's the gift tax year. And whatever that gift tax is at the time of the transfer, would normally be the year that you would have to impose that tax. But because of the lifetime gift tax exemption, there is a certain amount. And as long as it does not exceed that amount, then you get that exemption. Okay. So let's talk about asset protection. Protection from creditors. Assets in an irrevocable trust are generally protected from the grantor's creditors, as the assets are legally now owned by the trust, not the grantor. When anything is transferred into the trust, it is now the trust property. And so it's separated from whoever transferred it into the trust. And now it is owned by the trust, and whoever might be exacting some sort of lawsuit or whatever other kind of issue with regards to a creditor, trying to get access to those assets, they do not have a clear path to get there because of the fact that now the assets are owned by the trust and not by the individual. Then there's legacy and succession planning. You have control over your distributions. The trust can specify the terms that control when and how beneficiaries receive the trust assets, which can be important when it comes to wealth planning and, managing wealth across generations. I've seen people put houses and land in a trust, and the beneficiaries are allowed to live there in the homes or to build on the trust property, and there's some potential for mismanagement when you are transferring, things to your heirs that you want them to share outside of a trust. And so sometimes, you end up with disputes and things of that nature. But when the assets are in trust and they're there for the beneficiaries, the trustee is the one that manages that process. And whoever the trustee is at that time will designate that you are to share the house and you can live here as long as you would like, according to what the trust has stated, And so, there are other things that, of course, that, you can look at here, but I'm just using a house as an example of, one way or one thing that could be shared amongst beneficiaries when in the trust. But there's so many others, and we've talked about some of them in previous presentations. And so as we're speaking today, we're just wanting people to understand that you have lots of flexibility here, when it comes to control over distributions. The trustee really does have the ability to follow the terms of the trust and make sure that the beneficiaries are well taken care of. So let's look at the steps. What are the steps to coordinated management? Well, the first thing is you got to establish a living trust. Okay. And the establishment of a living trust, can be done several ways. Many people think that only an attorney can establish your trust. And this is absolutely not true. I've seen people do the DIY method. They can do the do it yourself. They've gotten online and put together their own living trust, use the kit or software to do so. They can use organizations like ours. We have a set of referral processes that, also will get people to estate planning attorneys or other professionals if they choose to do that. But we have a program that we do establish for people, the ability for them to get some education with regards to trust. And while doing that, if they utilize our relationship with Precision Management Group, Precision Tax Advisors, they can have their trust documents prepared for them for free. So we have that service at our in our organization. And you can establish a living trust or a joint living trust if you're married or have a registered domestic partner. But you also need to incorporate an irrevocable family trust for this seamless management to occur, where you can utilize both the living trust and the family trust together. You could actually have your irrevocable family trust as the beneficiary of the living trust and actually have the assets move, to the irrevocable family trust when you pass away. That's a very common practice that we've seen. We also have seen people have their irrevocable family trust as the ultimate beneficiary of a living trust, which could mean that if something happens where the parties that they do have designated as beneficiaries are not available, they are not alive to receive whatever is in the living trust, then at that point, then the irrevocable family trust could get the assets. They're very strategic ways that people make these things happen. So step 1 and step 2 are, the first 2 steps to making this coordinated management a possibility. Step 3 in the coordinated management process is actually coordinating. Okay. So what does that mean? Well, harmonizing the provisions, making sure that the provisions in both trusts don't conflict and that they work together to really achieve the objectives. Because sometimes, if you have an older living trust and you try to pair it with a new irrevocable trust, the irrevocable family trust might have things in there that contradict what the living trust states. So you need to make sure that you're always, aligning the 2 documents. Okay. And if you are the creator of your living trust and you have still life in you, then I would say that you need to be making sure that you're keeping up every quarter or semi-annually, or I should say biannually, or maybe even annually, making these reviews happen so that you can, if you're making changes inside of the living trust, that those changes still reflect what the irrevocable family trust is embodying. And if not, then the trustee needs to be aware of what's going on so that they can coordinate. Okay. And for succession planning, you got to coordinate your beneficiary designations and successor trustees across both trusts to make sure that there's a smooth transition and management continuity, because sometimes there's not the same person who's operating as your successor trustee, who's the successor to you when you pass away for your living trust, and the person who is actually the trustee in the family trust. Those people might be different people. And so there needs to be a handoff, and that handoff needs to go smoothly. So you got to put things in writing to make sure that happens, and then you got to adapt to change. You got to, like I said, regularly review and update the terms in the trust to make sure that they'll align with the grantor's wishes, family circumstances, and changes in the law. A lot of people think that you can't make changes to the irrevocable family trust because of the fact that it states that the grantor cannot revoke the trust. However, if the laws change, then amendments have to be made. Recently, there were some laws that changed in the United States about common law trusts, and those laws, they changed in different states. They didn't change, unilaterally across the federal, revenue procedures or anything like that. The laws changed in separate states, and those states who are no longer allowing their banking institutions to, take advantage of a common law practice that used to be in tow. It's no longer a part of some of those states' rules. And so banks like Chase will no longer open up accounts in certain states for people who have trusts with common law language in it. And we've seen that happen where several banks, not just Chase, we saw it happen with, BMO would not open up, or US Bank, which is Union Bank for the commercial side of what they do. They won't open up a trust that has common law language in it because that's no longer a acceptable type of document in the banking institutions and in some states. And so we have to adapt, and there needs to be the amendments made to make the changes to those trust documents so that they can stay compliant with the banking laws, and that is really important. And so if you have the knowledge, then you need to be looking at, if you're a trustee, making those changes so that your document stays compliant and your accounts won't have to close. Okay. Or for that matter, you'll be able to get an account open. And then consult with professionals. You need professional guidance. Even if you do the DIY method, you need to have somebody look over your documents from time to time to make sure that they still are compliant. If you're not savvy enough to find out where that information is available, we have a free service that we offer. We will review their trust documents for free. And we have legal software, and we have a legal team that we have access to if necessary. We've got, international attorneys that we can, pull on if we need to have them take a look at some things. So, our organization is here for you to assist you with these processes. But then we also have good referrals. If you would prefer an attorney, then we'll send you right to, a group of attorneys. We have relationships with Rocket Lawyer, and we have relationships with some other legal associations that, have the ability to serve you if what we offer is not enough for what your needs are. So we are here to make sure that, you get the best possible service in this way. But we really do appreciate, the fact that you trust us enough to even watch this presentation. We want to help you understand that having a well-structured plan is so important. And it's when you use both the living trust and the irrevocable family trust together, it does provide a robust mechanism for your asset management, protection, and transfer. The strategy offers flexibility during the grantor's lifetime with a living trust, and stability, and protection after you have gone home, and this is important for you to understand that your estate does not have to end with you. You can protect it. You don't have to have things go through probate if you do not desire for that to happen. By carefully designing both trusts to work in concert, you can effectively secure your legacy, minimize your estate taxes, and provide for your heirs in a controlled and protected manner. Well, this has been Patience Rose, and I have been so excited to bring this to you today. We have been looking forward to doing this for some time now, and so we are excited that you have been able to participate in what it is that we've done. We are open for questions. If you have questions, we have places on our website where you can go at redworldwide.org and, go there and, click on the area where you can set an appointment if you want to talk about this further or talk about your specific needs. We are here to make sure that, you get your questions answered and that you are able to properly plan, to make sure that you have reduced your risk and taken away the vulnerabilities that you and your family may have when it comes to your estate and planning for your legacy and for your future. Thank you, and we'll see you again next time.